Audible? Am I audible? Yeah, thank you. So, see, totally I was allotted 6 classes. I've completed my portions in the last 5 classes itself. So this class, what I thought was for the benefit of students who would have missed few classes here and there, and a quick revision of. I've totally covered 13 chapters. So all 13 chapters, we will see a quick revision of all 13 chapters, and that would go for 1.5 hours to 1 hour 45 minutes. After that, we will have a doubt clearing session where your common doubts with related to the subject you can post, and I will try to answer to the best possible. And after clearing your doubts, the last few minutes, we will discuss how to write this paper in the examination. Okay, so this is the plan for today. We'll start. Okay. So I am closing the chat as of now because it would disturb me a little bit. I will open the chat after some time. See, this particular chapter normally tells about, as a company secretary, you will be handling the first common thing that all company secretaries will undergo is to set up some organization. They would come to you seeking an advice, asking to give them a suggestion what kind of organization they would like to have. They are doing some business and what type of organization they have to register. So it is very essential for a company secretary to know what are the different types of organizations that are available and how to register them, and what are the merits and demerits of each and every organization, and which one to prefer when. So you are supposed to have in-depth knowledge in all these items. And suppose if there will be few people who would have started these organizations, but then due to some reason they would like to close these organizations. So how do you have to close these organizations will also be seen in this chapter. So how do you set up these organizations and how do you close these organizations? Because you will be in a position to advise them to say you can prefer this type of an organization, and you will also facilitate them in doing the incorporation process. So the first chapter normally talks about choice of business organization, where they are talking about different types of organizations, where it was included sole proprietary, partnership, Hindu undivided family, limited liability partnership firm, branch office, cooperative societies, and companies. So there are all these different types of organizations which are available that we could normally prefer. But how can I decide? How can I decide whether I should go for a sole proprietary or to a partnership or a HUF or a cooperative society or a branch office or a company? How do I decide on which type of organization would best suit me? So there are different factors that would determine the decisions that are taken on preferring the best type of organization. So these factors that would govern are broadly classified into 16 types. So when I talk about 16 types, so what all will be included in this? See, I'm not going to explain everything again because we are doing a recap, but where here and there where I feel like here more importance have to be given, there I will explain it more. Okay, so 16 points have to be kept in mind before I select the best type of entity that is required for me. So what are the 16 are? The nature of business activity, the scale of operations, the capital requirement, the managerial ability. So because there can be some persons who can do work by themselves. There will be certain situations where I need the professional's help to do my business. So managerial ability, degree of control and management, stability of business, flexibility of administrations. When I talk about flexibility of administration, if I'm a sole proprietary, I can take my decisions on my own. If I am a partnership firm, still I can, partners can decide and they can take decisions on their own. But however, if it is a company, apart from our own decision, we'll have to also see what does the act say, what does the MOA say, what does the AOA say. So there's no much flexibility. So flexibility, division of profits. So how do we divide the profits? Cost, procedure, and government regulations in running that business. Tax implications, geographical mobility, transferability of ownership, managerial needs, secrecy, independence, all these factors. Okay, so starting from nature of business activity till independence, whatever I said, these would normally uh, play a major role in determining what type of organization I'm supposed to have. Even though there are a lot of type of organizations, say sole proprietary partnership, HUF, and all these things, as a company secretary, we will be mainly concentrating more on companies. So when I talk about companies, companies can be broadly classified into three types. So what are those three types of companies? One is one-person company, second one is a private limited company, third one is a public limited company. So when I talk about a one-person company, there are certain characteristics for a one-person company. Only one member has to be. Yeah, all your doubts, I will answer all your doubts in the doubt session. Now let's do a quick recap of all the chapters. I just want to cover all 13 chapters in the next 1.5 to 1 hour 45 minutes. Okay, so we'll just quickly go through it and you can post your doubts. We will spend nearly 45 minutes for clearing all your doubts. Okay, so just concentrate, just come along with me. Because when you're posting your doubts in the chat box, I feel distracted because I'm seeing that. Okay. So one-person company, there are certain characteristics for a one-person company. When I talk about characteristics, only an individual can be a member. He has to be a citizen. He has to be a resident. He has to have a nominee. You have a capital cap and a turnover cap, beyond which if you go, you'll have to become a private limited company. So there are certain restrictions where only a single person, instead of a sole proprietary, one-person companies are now preferred. Okay, this concept is introduced in the Companies Act 2013. Coming to a private limited company, private limited company is again two or more people having idea of doing business together with limited liability. The maximum number of members that I can have in a private limited company is 200. And coming to the public limited companies, where all other company which is not a private limited company, because in a private limited company there's a definition which will define what a private limited company is, where the definition says maximum 200 members. When we are talking about the maximum 200 members, one thing that we have to remember is it does not include the present and the past employees of the company. So if there are 1,000 employees in the company and all the 1,000 are shareholders in the company, in the count of 200, those 1,000 will not be considered, because it excludes, the definition itself excludes present and the past employees, and which restricts the transfer of shares. When we talk about restricting the transfer of shares, it doesn't mean that the shares cannot be transferred. It is not saying the transfer of shares are prohibited. What it is saying here is it is restricted. When we say restricted, subject to certain conditions. So what conditions are required to be done is the transferor and the transferee has to execute a share transfer deed, which is the share transfer instrument. This deed has to be taken on a prescribed format, which is SH4, which has to be then submitted to the company. The company will take note of it, and only if the directors approve, the transfer will take place. That is why it is called as restricted. Okay, so which also prohibits invitation to public to subscribe its shares, which means like they cannot issue prospectus. So these are all private limited company definition. All these includes in the definition. So public limited company is a company which is not a private limited company, which has more than 7 members in the more than 7 members in the company. And one more thing, even though I'm a private limited company, if I am a wholly owned subsidiary of or a subsidiary company of a public limited company, then in case, even though I'm a private limited company, I will be treated as a deemed public company. Okay, so companies are broadly classified into these three types, but further companies can further be classified based on few other criteria. For example, classification on the basis of incorporation, classification on the basis of liability, and other forms of companies. Okay, so when I talk about classification on the basis of incorporation, we all know if I want to register a company, I have to register it under the Companies Act. But there are certain special acts which are there, like say RBI, LIC, all these organizations are incorporated by a special act which is passed in the parliament. So all these companies are not uh, registered under the Companies Act. These are registered by way of a special act which is passed in the parliament. So those type of companies are called as statutory companies, and all of the companies which are registered under the Companies Act are called as registered companies. So this is the difference between a statutory company and a registered company. Coming to classification on the basis of liability. So when we talk about liability, again it is broadly classified into three types: unlimited liability companies, companies limited by guarantee, companies limited by share. Unlimited liability companies can be with shares or without shares. But when we talk about unlimited liability, all the members of the company will have unlimited liability. In case there's a default in repaying, all the members' personal assets also can be attached. However, when we talk about companies limited by guarantee, what are they saying here is, at the time of incorporation itself, in the memorandum of association, in the subscriber clause, they will mention it very clearly that suppose if the company is getting wound up, and at the time of winding up, if there is any default in repaying the loans, then we guarantee, okay, the members guarantee to repay a certain amount of money. So they guarantee at that point of time. So that is companies limited by guarantee. And companies limited by shares, where shares are issued and where the liability is limited only to the extent of unpaid share value. Okay, and there are other types of companies also. There are other types of companies also when it comes to the broad classification of companies, which are like the Section 8 company, the government company, foreign company, holding and subsidiary company, associate and joint venture companies, investment companies, producer companies, nidhi company, dormant company, non-banking financial companies. So when I talk about quickly about what a Section 8 company is, a Section 8 company is a not-for-profit organization which is registered under the Companies Act, which has an objective of promotion of art, science, literature, and all these things. And few more things about a Section 8 company is they have to make sure that they can earn income, but it should not be a distributable income. So dividends, distribution of dividends is prohibited. And suppose if you're going to close a Section 8 company, the promoters cannot take the money what is there in the Section 8 company. Rather, what has to be done is all the assets of the Section 8 company should be transferred to another Section 8 company, or it has to be transferred to the insolvency and bankruptcy fund, which is maintained under IBC. Okay, so this is all about a Section 8 company. Coming to a government company, all companies whose shareholding where 51% or more of the shareholding is held either by the central government or by the state government, or jointly by the state government or the central government. In all these cases, it is called as a government company. Foreign companies, what is a foreign company? A company which is registered outside India but has a place of business in India is a foreign company. The next comes the holding and the subsidiary company. When I talk about the holding company, there are a few characteristics where if a company is holding more than 50% of the shares in another company, then the company which holds the shares will become a holding company. Or if a company is able to control more than 50% of the board of directors in another company, or if a company is having the power to appoint more than 50% of the board of directors in the other company, which means that this particular company has a control over the other company. In that case, the controlling company will be called as the holding company. So it can be by way of equity or by way of control. And the company which gets controlled is called, or whose shares are bought by another company, is called as a subsidiary company. Then what I will do is your questions. I will answer to all your questions. Okay, fine. If you want to post it, you keep posting it, but I will not, because that will break the flow. I will answer everything after I explain these concepts. Okay. Coming to the associate company. Associate company are those companies where there is a significant influence, When I talk about a significant influence when a company is said to have a significant influence in another company when a particular company holds more than 20% of shares in another company. However, less than 50% of shares. Because if it is going to become more than 50%, it is going to become a subsidiary company. So to be classified as an associate company, it should be between 20 to 50% is called an associate company. A joint venture company is where two companies which are planning to come together to do a project where both have their own competitive advantage. And for a particular project, when both companies are going to come together, either by forming a new entity or by way of a collaboration, it is called as a joint venture company. Like earlier, there was Hero Honda, Sony Ericsson. All these are basically joint venture companies. Coming to investment companies, these companies are basically whose primary activity is only to invest in the securities of another company. Their income will be mostly derived from, which means that 50% of their assets will be in investment assets, and 50% of their revenue will be generated from those investment assets. Just like in NBFC criteria, 50-50 test has to be passed, which are called as an investment company. Coming to a producer company, what do you mean by a producer company? Companies which are registered under the Companies Act and having their objectives as per section 581 capital B of 1956 Act is called as a producer company. Why did I say 1956 Act? Because as per Companies Act 2013, section 465 subsection 1, it clearly says that as far as producer companies are concerned, the old act will prevail mutandis mutandis, as if the new act has not come into effect. So for producer companies, old act is applicable, where to start these type of companies, all members should be farmers or producers. Basically, producers means persons who are involved in agriculture, horticulture, sericulture, fishery, animal husbandry, beekeeping, plantation, handloom, handicraft, revegetation, and like activity. All these type of activities, if a person is involved, he is called as a producer. Only he can be a member in these producer companies. Coming to the next one is a Nidhi company. A Nidhi company, basically talking about a Nidhi company, these type of companies are who are only into the activity of giving loans or accepting deposits only from its members. The only objective that a Nidhi company can have and can do is to accept deposits, to give loan only to its members. So because they are doing their business only with their members, RBI has given an exemption from getting registered under RBI. So Ministry of Corporate Affairs is only the regulator for Nidhi companies. Coming to dormant companies, dormant companies are normally it can be a private limited company or a public limited company. But when we talk about dormant company, what happens here is they don't do any activity for a certain period of time. So any company which is inactive and where there is no significant accounting transaction for a continuous period of 1 year from the date of incorporation, or for a continuous period of 2 years from the any time after incorporation, in that case a company can apply itself to become a dormant company under section 455 of the Companies Act. So I have to apply to become a dormant company. Just because I'm inactive, I will not become a dormant company. If I'm inactive and if I stay inactive, my name will be striked off. I cannot become a dormant company. If I want to become a dormant company, two conditions to be satisfied, which is inactive and there's no significant accounting transaction for 1 year from the date of incorporation, or for any 2 continuous years. In that case, under section 455 of the Companies Act, I can apply for a dormant status. Okay, so when I talk about inactive, means we know there's no transaction which is happening and there's no significant accounting transaction. The word significant here plays a very important role. When I talk about no significant accounting transaction, these transactions normally exclude your office maintenance expenses, your running expenses, the fees that you pay to the registrars or statutory dues, the money that you spend for allotment of shares. Excluding all these things, there is no any other financial transaction which is called as a significant financial transaction. Okay, so this is all about a dormant company. Then comes the last one, is a non-banking financial companies. Even though there are a lot of banks which give loans and accept deposits, most of the customers, if you see more than a bank, 15% of the NBFC customers have more customer satisfaction. The reason being here is because there are a lot of advantages for a non-banking financial companies over banks, like easy processing of loans. Even though there's a low credit rating, you get quick loans, okay, competitive interest rates. So all these things made the non-banking financial sector more attractive for consumers to approach them. And that is why this particular concept is also growing in the past and in the future. In the present, a lot of NBFC companies are growing. Okay, so these are basically what an NBFC company. These are different forms of organization. Okay, I have explained you what is the definition of a private limited company, but then let us cover a little bit about what are the characteristics of a private limited company. Who can be a member in a private limited company? An individual can be, or any body corporate can be. When I talk about a body corporate, who can be a body corporate? Any entity which has a separate legal entity is a body corporate, but it specifically excludes a society. Society also has a separate legal entity concept. However, those are specifically excluded from body corporate definition under the Companies Act. So apart from societies, any entity which has a separate legal entity concept, where it can enter into contracts in its own name, can become a member in a private limited company. So the question here might come is, can a trust be a member in a private limited company? The trust cannot be a member in a private limited company. However, the trustees can be a member in a private limited company. So these are all about the membership, and minimum 2, maximum 200. We've already seen that. Talking about the liability, when we talk about the liability, it is limited. However, based on the type of company that we register, it can be an unlimited company or company registered with guarantee. The liability would differ. It has a perpetual succession, which means that it was incorporated. I will explain you the incorporation process. So it was incorporated by following a particular process, and so it can be closed only by following a particular process. It was formed by law, and it can be closed only by act of law, which is called as a perpetual succession. Index of members, where there are more than 50 members. The members register should have an index of members. The minimum number of directors are 2. The maximum number of directors are 15. However, if you want to have more than 15 directors in a private limited company, you can still have by passing a special resolution. When it comes to the paid up capital, there is no minimum paid up capital requirement. You can start a private limited company with any number of with any amount of capital. And prospectus, issuance of prospectus is prohibited when it comes to a private limited company, so that a private limited company cannot approach the public and openly say, come buy shares in my company. Okay, and let's talk about the incorporation process. A lot of you were asking what is the incorporation process that is involved. So when we talk about the incorporation process, first what we have to do is we have to decide who the members are going to be. Okay, and we have to collect certain type of proofs from those members, like everyone's PAN card, everyone's ID proof, and everyone's address proof. When I talk about ID proof, there are 3 types of ID proofs, which is the voter ID or driving license or passport. And when I talk about the address proof, there are 4 types of address proof, which is bank statement or EB bill, or EB bill means electricity bill, or telephone bill, or postpaid mobile bill. Any one of these 4 of the residence proof, any one of 3 of the ID proofs, and PAN card is compulsory, and you should have a passport size photo. These are the basic documents that you will have to collect first from the members, proposed members. After all the documentations are collected, the second step that you do is you apply for a digital signature. So when you talk about a digital signature, see, this is how basically a digital signature will look like. Okay, so this is our digital signature. It looks basically like a pen drive. So what these are used for is, I will just use, I'll just put this in the USB card, and the signature of the members will be encrypted inside this particular token. So we don't call it as a pen drive, we call it as a token. So the signatures of the particular members will be encrypted inside those tokens, and using that, I'll have to make this filing. Why I have to use a digital signature to make the filing is, Ministry of Corporate Affairs has done a lot of changes when it comes to incorporation. There was a evolution among the incorporation forms. Right now, what is there for incorporating a company is Spice Plus. So what used to basically happen is, under the Ministry of Corporate Affairs, there used to be regional offices which is headed by the regional directors, and the regional director's office again takes control over certain registrar of companies, which is called as the ROC. ROC is already held up with a lot of work. So in order to make incorporation process more simplified, they have formed something called as CRC. CRC refers to Central Registration Center, which is located in Haryana, all over India, from Kashmir to Kanyakumari. Wherever you're going to register a company, your company application goes only to CRC for its approval. Okay, so it's an online process. It goes only to CRC, and they've tried to make more registrations along with the incorporation process itself, like getting the DIN numbers for the directors, getting PAN card, getting the TAN card, TAN number, getting your GST registrations, getting your PF registrations, getting your ESA registrations, and opening a bank account for a company. All these things have become an integrated form, and all these things can be applied in the Spice form itself, which is now the Spice Plus form. Why do we call it as a Spice Plus form? Because it is an online form now. Earlier it is a web-based form. Earlier it was an e-form. Until it was an e-form, we used to call it as Spice form, where it was called as Spice 32, and EMOA was called as Spice 33, and EAOA was called as Spice 34. Now what has happened is everything became a web-based form. So you have to log into your Ministry of Corporate Affairs website, and you'll have to fill the Spice form. When we talk about the Spice forms are basically divided into two parts, Part A and Part B. Whenever I am going to register a company and I'm applying for a name, it has to be done only through Part A of Spice Plus B form. Earlier, there was a provision for applying for name in RUN, Reserve Unique Name, which used to be available in the Ministry of Corporate Affairs website. However, now the RUN can be utilized only by existing companies when they want to change name. When a new company wants to get itself registered and wants to reserve for a name, it has to apply only through Part A of Spice B. So you will apply in Part A of Spice B, and you'll have to wait for some time until it is approved by the registrar. There are two options here. Either you can apply for the name and continue with Spice B and submit all the documents together, or you can apply for name, wait for its approval, and then you can submit Part B. And if it is approved, it will be valid for 20 days, within which Part B has to be submitted and has to get approved. Whenever we are talking about naming a company, certain points have to be kept in mind. Like the proposed name should not be similar or identical to any other existing company name. The proposed name should not be similar or identical to any other registered trademark. The name should not have any patronage with the central or the state government. The proposed name should not affect the integrity and sovereignty of India. The proposed name should not be against the emblems and symbols that are basically used. So there are certain conditions within which I'll have to apply for name. And provided all the naming guidelines are satisfied, my name will be reserved for the next 20 days. Within this 20 days, Part B has to be submitted. So in Part B, I will fill all the directors and the members' particulars. And after Part B is filed, automatically another form called as Agile Pro will be created. This Agile Pro only facilitates a company to apply for GST, PF, and ESI. Agile Pro. After Agile Pro, EMOA, EAOA will be generated. So in case if you want to enrich your articles or memorandum, in that case you will enrich your articles, and then after EMOA, EAOA, INC9 will be generated. So all these forms, which is the Spice Plus, Spice B form, Spice Part B, so Spice B form, the Agile Pro, EMOA, EAOA, along with INC9 declaration will have to be after filling have to be downloaded, and you have to use these digital signatures to sign all these documents, and you will upload everything together as a linked form. And after scrutiny, if the registrar is satisfied, he will issue a certificate of incorporation with which your company registration is over. Here, talking about the registered office address, there are two points to be remembered. At the time of incorporation itself, you can say what is your registered office address, or there will be certain cases until the company is registered, I have not decided where I'm going to do my business. So after the company is registered, within 30 days, I have an option to intimate about my registered office address. This will anyways will have to be mentioned in Spice B itself, whether this is a temporary address or a permanent address. If I'm going to say as a temporary address, registered office proofs need not be submitted along with Spice B. However, when I say it is a permanent address, registered office proofs have to be submitted along with Spice B. So when we talk about registered office address, there are totally basically two different types of proofs which are required. One is the address proof and the second one is the utility proof. When I talk about the address proof, it can be a sale deed, a lease deed, a rental agreement, or a property tax receipt. And whenever I talk about a utility bill, it can be electricity bill, it can be gas bill, it can be telephone bill, it can be water bill. And whenever I'm going to give any document apart from lease deed or rental agreement, and an NOC, a no objection certificate from the owner of the premises should also be given, saying that they have no objection the company having its registered office address here. This has to be submitted in Spice B itself if it is a permanent address. Suppose if it is a temporary address, then after the company is incorporated, within 30 days, I'll have to file a form which is called as Form INC 22, in which I will be mentioning this is my registered office address. Okay, and after that, can I start my business? The answer is no. There's a new form which has been introduced, which is called as the declaration for commencement of business. Unless I declare saying that I'm going to start my business, I should not start my business. So to declare that I'm going to start my business, what is required is I would have started my company, say, with 1 lakh capital or 2 lakhs capital. That 1 lakh or 2 lakhs should be deposited into the company's bank account. And then a statement of that 1 lakh or 2 lakh has to be taken, scanned, and has to be submitted to the ROC, saying that I'm going to declare commencement of business in Form INC 20 capital A. Form INC 20 capital A. So using this form, certificate of commencement, declaration for commencement is filed, and after that, the private limited company is set to go and do its business. And all these proofs, whatever I said, the PAN card, the ID proofs, the address proofs, is when an individual is a member. There can be situations where even a corporate entity, another company or a body corporate can be a member in a company. In that case, what kind of documents will be required is a board resolution copy stating that that company would like to invest in the newly proposed company, the number of shares that they would like to purchase, the person who's authorized to sign on behalf of the company, and all other authorizing him to do any other activity which is related to facilitate the incorporation process. So a board resolution copy. Second one is the certificate of incorporation of the body corporate, and the ID proof and the residence proof of the authorized representative who is going to sign on behalf of the company. So these will be the extra proofs if it is a body corporate who is a member. And suppose there will be situations where a foreign entity or a foreign shareholder, a foreign individual would like to invest in this company. And whenever a foreigner is going to come, the basic thing that you will have to keep in mind here is all the documents has to be either notarized or apostilled in their country, and they have to send it here. So whatever documents are related to that foreigner, it can be the ID proofs, it can be the address proofs, it can be the documents that they are signing, all the proofs, whatever they send has to be either notarized or apostilled based on the type of country they belong to. It has to be either apostilled or notarized in that country, and then they have to send it here. And I've told you that there's an EMOA and EAOA which will be generated along after Spice B in the web form itself. However, there are certain situations where physical MOA and physical AOA are still in practice. When physical MOA and physical AOA, which means that MOA, AOA will be an attachment, it will be taken on a paper, we will sign it, we will scan it, and we'll keep it as an attachment to Spice B. When will it be as an attachment to Spice B is basically whenever there are more than 7 subscribers, whenever we are going to register a Section 8 company, and whenever a company is going to have a foreign subscriber, in all these cases, it will be a physical MOA and physical AOA. And so this is all about the incorporation process. It's pretty simple. And when we talk about DIN numbers, if I'm going to register a private limited company, the maximum number of directors, DIN numbers that I can get in the form is up to 3 directors. And when I'm going to register a producer company, the maximum number of directors that I can apply is for 5 directors. Okay, because the minimum requirement is 5 for producer company. For a private limited company, even though the minimum requirement is 2, they are giving still provision up to 3 directors where I can get DIN numbers in that form itself. Apart from that, if I want, I'll have to apply separately. And SPICE form, there is no fee for stamp for the SPICE form. It is a 0 fee form. However, for the PAN card, for the TAN number, you will have to pay, which for PAN card you will normally be paying 110 rupees, and for TAN number you will be paying 65 rupees, and your particular stamp duty up to 15 lakhs. There is no big stamp duty, where it would differ on an average of 2,000 rupees per. On state there is less also, there's more or no. On an average you can keep 2,000 rupees as MOA stamp duty. And after the company is incorporated, for the INC 22 and INC 20A, whatever I've said, for those the normal fees will be 400 rupees each. So this is all about company incorporation process. Then we saw what a public limited company is, what is a deemed public limited company, talking about few characteristics of a public limited company, talking about the board of directors, minimum 3 directors, maximum 15 directors, more than 15 also I can still have directors, but by way of passing a special resolution. When I talk about the liability, it is a limited liability. Number of members, minimum 7, maximum unlimited. Lifespan, again perpetual succession. Financial privacy, there is no much financial privacy, because when it is a public limited company, my financial information is published in various forums. And this is all about a public limited company, and we a little bit of a 1% company. We've already seen what a 1% company, when one shareholder is going to hold shares in a company is called as a 1% company, and all these things. In India, from 2005 itself, they've been discussing about 1% companies. However, JJ Irani committee, they made a recommendation, let's start this 1% company, because these 1% companies are already in existence in countries like UK, Australia, Singapore, Pakistan, China, US. So this is not a new concept. These are already in existence in all these countries, where there will be 1 member and only 1 director, 1 member and minimum 1 director. The member will be itself the deemed director of the company. However, there are few restrictions for these type of companies, where they cannot carry on non-banking financial company. They cannot become an NBFC company, or they cannot become an investment company. We've seen these type of companies which will be investing in some other companies, because 1% companies are basically not allowed to invest in any other company. Okay, and if I'm going to register as a 1% company, immediately can I get converted into a private limited company? The answer is no. I'll have to wait for 2 years for me to get converted into a private limited company. However, if my threshold limit exceeds within these 2 years, which is more than 50 lakhs of paid up capital or 2 crores of turnover, in that case, I will be forced to get converted into a private limited company. And 1% company, few more things that you'll have to remember is appointment of nominee is very much important. The nominee details you will be mentioning at the time of incorporation itself. The same SPICE B will be filled even for 1% company. The name should end with OPC Private Limited. All the other documentation remains the same. However, when you keep there for a private limited company for 2 people, in 1% company you're going to keep for 1 person and for 1 nominee. Okay, and the member has to be a citizen and a resident, and the nominee should also be a citizen and a resident. A minor cannot be a member or a nominee in a 1% company. Okay, and after the 1% company is incorporated, even these 1% companies are treated as a separate legal entity, which means that they can enter into contract with their own members. And when we talk about there are a lot of type of companies where we saw companies with share capital, companies without share capital, companies limited by guarantee, and all these things. Based on the type of entity that a company is going to get registered, the MOA and the AOA that they are going to adopt would differ. When I talk about the MOA and the AOA, for MOA there is from table A to table E, and for AOA there is table F to table J. So where table A normally talks about companies limited by shares, table B is applicable for companies limited by guarantee, not having share capital. Table C is applicable for companies limited by guarantee having share capital. Table D is applicable for unlimited companies not having share capital. Table E is applicable to unlimited companies having share capital. When we are coming to AOAs, Table F is applicable for companies limited by share. Table G is applicable for companies limited by guarantee having share capital. Table H is applicable for companies limited by guarantee not having share capital. Table I is companies with unlimited liability and having share capital, and Table J is for unlimited companies not having share capital. So these are the different types of AOA that would normally be preferred. And talking about your now MOA and AOA, we'll have to know what does an MOA and what does an AOA mean. Just before we proceed, I'll just take a I'll just stop for 1 minute. I'll just see your questions, because if I keep continuously talking, following up would be difficult. So for 1 minute, I'll just see your questions, and then again we'll continue with what an MOA, AOA is, and how do we amend an MOA and AOA. Okay. So yes, there have been a lot of questions. Insolvency resolution process and all was over. Anyways, we'll be covering insolvency also today. We've completed all the chapters and we're just doing a recap now. What do you mean by independence as a criteria of selection of company? See, when I'm a private limited company, when I am a sole proprietor, I have my independence to decide what business I have to do, whether I have to sell off few assets, whether I have to adopt new technology, or I have to go for expansion. I have my independence to decide. But when I'm a company, I have to go to the shareholders, get their approval, make sure the quorum is present. So the independence is not that much when it comes to a company form of a business. So that is what it influences. Kindly send amendment of Company Act rules during one last year if available with you. It is not available with me. Can the guarantee amount be changed in MOA during the lifetime of the company? Yes, it can be changed. Can you repeat what happens to the net worth of the Section 8 company if it is wound up? Shareholders cannot take excess. Where should it be transferred? See, for a Section 8 company, see, there will be a lot of funding which will come to a Section 8 company. It through way of donation, all these things, and I have tax exemptions also, so I'll not be paying tax also. So there will be a lot of assets which are getting accumulated for the Section 8 company. Why did I get donation, or why did I get these tax exemptions, or why did I get the government support? Just because I'm doing some good activity. After I get all these things, if I'm going to wind up the company, take all the money and go, it is of no use. So they made a block over there. If you're going to close your company, you cannot take the money and go. What you have to do is you have to transfer your assets to another Section 8 company with similar objectives. Okay, to another Section 8 company with similar objectives, or it has to be transferred to the insolvency and bankruptcy fund, which is maintained under Insolvency and Bankruptcy Code. Okay, so this is what will happen to a Section 8 company. Can you explain incorporation process? I've already explained. As JV always 50-50, else it would become holding subsidiary relationship if anyone is having more than 50%. No, it is not that way. They are not. JVs can normally be of two types. One is equity-based JV, non-equity based JV. When it is an equity-based JV, a new company will be formed in which both the entities will do some contribution, and if in that equity based company, if one company is having more than 50% of stake, then obviously yes, it will become a holding company. In non-equity based joint venture companies, what would normally be is they will have terms and conditions saying that I will contribute so much, you contribute so much, this will be your role, that this will be my role. So it is basically not a holding and subsidiary relationship, it's a contractual relationship when it comes to joint venture companies. And PA Radha, producer companies normally start from Section 581 capital A to Section 581 ZT, correct? That is only still applicable even today. Sir, once explain incorporation process of a company. I've already explained what is the incorporation process. Trustee can be a member of a company on behalf of a trust or on his individual personal capacity. On behalf of the trust also he can be. On behalf of the trust also he can be. What are the 3 ID proofs for members while incorporating? What is the full form for CRC? So the 3 ID proofs are your voter ID, your driving license, or your passport. The full form for CRC is Central Registration Center. Okay. For INC 22, separate part B also to be submitted to CRC or not, and not to ROC. For INC 22 will be submitted to ROC because after the company is incorporated, automatically the control will come to the CRC. So it will come to CRC. It will be taken over by CRC until the company is registered, which is the Spice B will go to CRC. The remaining will come to ROC. What if INC 20 are not filed and the company carry on its business? If a company does not file its form INC 20A, all the directors of the company will be liable for a penalty of rupees 50,000 rupees, and the company's registration also can be cancelled by the registrar of companies. That would be the violation if form INC 20A is not filed. What is the process of setting up a branch office outside India? So when we talk about branch office, setting up of a branch office, these concepts called as a branch office or a license office, all these things require RBI approval. So I'll have to go to RBI, and RBI will check your track record, saying that you should have at least 3 years of track record. You should have an investment size of so much. They have a capital criteria also. If that is satisfied, RBI will let you to have a place of business in India. And after you have a place of business in India, you'll have to anyways intimate the ROC saying that, yes, I have a place of business in India. I'm doing my business here. Okay. So this is how normally branch offices will be set up. When the alteration can be done in MOA and AOA. See, MOA and AOA can be altered anytime after a company is getting incorporated. For the alteration of MOA and AOA, there are different processes that are involved, which I will be explaining in some time. The next thing that we are going to discuss is about MOA AOA only. Okay. What is the process of setting up branch office outside India, multi-state cooperative society? So I think you have 2 questions in this. Setting up of a branch office outside India is normally called as overseas direct investment, where apart from getting the local approvals, the country in which you're going to set up your branch office, they will have their own guidelines and regulations. So from country to country, that would differ if you want to have a branch office outside India. And setting up a multi-state cooperative society, these are basically cooperative societies where, for the benefit of its members, they operate in more than one state in India, and they have opportunity to work all pan-India level. Whenever I want to get registered as a multi-state cooperative society, it is done by the central registrar, which is located in Delhi, where individuals can be members or institutions can be members. When individuals are members, I'm called as a primary institution, and whenever an institution is a member, it is called as a federal institution when it is talking about a multi-state cooperative society. And whenever I'm going to register, make an application to the central societies registrar to register a multi-state cooperative society. 50 members from each state have to give a representation saying that please register this and give. And if it is an institution which are members in case of federal institutions, then minimum five societies in each state, 2 states should give a request to the central registrar saying that grant approval. On these approvals, multi-state cooperative societies will be incorporated. Okay. What is underwriting person under a Companies Act? See, whenever there's an issue of shares, this is basically, this question is related to Companies Act, which is not my subject, but still I will tell my understanding. I will try my best to answer all your questions in this. What is underwriting person? When a company is issuing shares, there will be some minimum subscription that a person that the company has to issue, or the issue will become a failure. So there will be certain people who will buy in bulk, and they will guarantee, even though people buy or not, we guarantee to buy this, and they in turn sell it to the outsiders. Okay, so these type of people who undertake to to ensure the issue happens properly, the minimum subscriptions will happen, and to sell the shares further to the members, certain agencies and certain companies run. These type of companies or persons are called as underwriting persons. Okay, the second question is, if a private limited company by default or deemed as a public limited company after it becomes subsidiary, then whether that subsidiary private limited company has to change the name and make alterations in the MOA accordingly. Not required. Not required. However, all the other provisions, which is like having the audit committee, having the nomination and remuneration committee, doing a secretarial audit, all these will now even for a private limited company, secretarial audit has become mandatory. But then earlier it was only for public limited companies. So these type of provisions will be attracted. However, they need not change their MOA and AOA or change their name. Okay. Even after winding up, the producer company has to follow. Even for winding up, the producer company has to follow 1956 Act, and whether NCLT will have the role in this case. See, there's a lot of practical difficulties which we are facing. If you see the Company Amendment Bill 2020, which is not yet notified, in that producer companies are bought into 2013 Act for this purpose only. Okay, so in due course, it will NCLT will only be taking care of winding up. However, when it comes to producer companies, one interesting fact here is Section 581 EZO specifically talks about when it comes to producer company, in case there's a dispute, it has to be resolved only through by way of an arbitration, which means that in case there's a operation or mismanagement or any other dispute between the member and a member, or a director and a director, or a member and a director, they cannot go to NCLT. They'll have to do it only through by way of a arbitration. However, yes, winding up, NCLT will have a say. Because after this amendment bill is going to get passed, and it will get passed now. And can it be said that the company like Muthoot Finance be treated as NBFC or falls under any other category? Yes, Muthoot Finance is an NBFC company. Okay, whether a creditor can opt for sending notice under IBC if already suit or arbitration is going on. Yes, a creditor can send. So a financial creditor or an operational creditor, they can file a suit if now they've changed the threshold from 1 lakh to 1 crore. So if there's a default of more than 1 crore, they can file a suit against these companies to wind up these companies or to liquidate these companies. And once NCLT takes that order, all the current arbitrations or current litigations, whatever is there will be a moratorium period where you're not supposed to continue anything else. After that, the NCLT will only take care. So yes, you can. Whether a creditor can opt for, yeah, this is red. If foreigner sending documents which are notarized in his country, again that has to come through embassy, or can it directly come to India through post or courier? It can come to India directly through post or courier. Most of the time what we'll do is, since it is an online process, we will ask him to scan and send it to us. It will not be posted or couriered. However, in case if the CRC ask us or demand us to produce the original copies, in that case we'll ask them to courier it. Apart from that, we need not normally ask him to courier it. After getting it notarized, we ask him to scan it there itself and send it across to us. Okay. Company seal, do you have, sir? See, company seal, I don't have it with me right now, but companies normally have a seal which is called as a common seal, which will be a metallic seal, which it will not be like this. It will be like pressing type with an impression over here. Once you press this gets pressed and only the impression will fall. There will be no ink for it, which is called as a common seal, which will normally be entered in the share certificates. And whenever a company is a party to an agreement, when company is taking loan in its own name, or when company is a party to an agreement, common seal will be affixed there. Common seal, whenever you're using it, it has to be approved in a board meeting, and then only you will have to use it. And whenever common seals are taken note of, in the minutes book, in the side, you have to put the impression of the common seal. There are so many things when it comes to common seal. Common seal is like the signature of a company. However, after 2013 Act has come, common seal has lost its importance. And it is a metallic seal. It will look like a metallic seal. You can just Google and you can type common seal. It will look like a metallic seal like this. It will be like pressing type. Okay. Multi-state cooperative society, I have already explained. Difference between shareholders and members. The shareholders and members, what is the difference between a shareholder and member? Once I am issuing shares to someone, okay, once I'm issuing shares to someone and he's subscribing to the shares, when he's going to hold the share, he will become a shareholder. The day his name is entered in the register of members, he will become a member. Okay, the time duration, the gap, these basically the words shareholder and member are synonymously used, are interchanged and used. However, they have a thin line of difference between both these concepts, where shareholders are persons who hold shares but whose name are yet to be registered in the register of members. Members are persons whose names are already registered in the register of members. And whenever my name is entered in the register of members only, there will be something called as a record date when I issue dividends. Who will be eligible for dividend? As on the record day, whoever is the member, only he will be eligible for dividend. Whosoever name is entered in the minutes book only will have voting right. In the members register will have voting right. They'll only have right to receive notice, the right to receive the financial statement. So it is just the time gap between the name getting entered in the members register, shareholders and members. Okay. There are no producer companies which are very famous, because producer companies normally work in a very small scale as of now. So if I name them also, you will not be able to understand about those producer companies. And sir, is in which cases 12A gets cancelled? So what do you mean by 12A basically? So 12A is basically given to a not-for-profit organization. It can be a trust, it can be a society, or it can be a Section 8 company. So these 12A registrations are basically tax exemptions that are given to these companies. So whatever income they get is tax exempted. These will get cancelled when the terms and conditions while giving itself, they'll say you'll have to use your funds in this way. You should not misuse the funds. You should do only charitable work. With certain conditions, these funds are given. And suppose if I'm not using those, if I'm not following those conditions, I'm doing as per my wish, the income tax department, the exemption department specifically, has the right to cancel a 12A registration. But INC 22 is filed before incorporation, right, for new companies. COA comes for that after that. So should it be filed to CRC for new companies? See, when it comes to INC 22, it will be filed with ROC. At the time of incorporation, there is an option whether you will say this registered office address is my permanent address or my temporary address. If I say it is my permanent address, then at the time of incorporation itself, I will file. If I'm going to say no, it is a temporary address, in that case, I will file it within 30 days from the date of incorporation. In that case, it will go to the ROC. And limit of number of members for a Nidhi company. So Nidhi companies also has the characteristics of a public limited company: minimum 7 members, maximum unlimited members. Okay. And in what cases RD comes into picture, or when we require RD approval for certain fulfillments? So there are number of number of cases where the regional director will come into picture. Certain basically whenever I want to remove my auditor between the tenure, whenever there is a charge which is has to be filed and I don't file the charge on time, I have to condone the delay, I go to the RD. Whenever I want to do some mergers and amalgamation, I go to the RD. So normally in all these cases, regional directors will come. There are a lot of items, so we cannot just put it in a nutshell and say there are certain powers which are given to RD. So in like this, can you explain waterfall hierarchy? I will explain you what is a waterfall hierarchy when we are talking about insolvency and bankruptcy code. I will be explaining it in some time. Okay. And who's a financial and operational creditor? I think a lot of things about insolvency is coming. I'll tell you what is a financial creditor and operational creditor, everything, because that's not then Kavita is asking when shares are pledged, the pledger is the member or the pledgee is the member? When shares are pledged, pledger is the member. Is it possible know that every shareholder name may not be on register as member. Yeah, there might be some cases where I would have missed by entering his name into the register. Okay. 12A is here is referred under not under Companies Act. I'm talking about 12A under Income Tax Act. Okay, so what we'll do is we'll just take a quick break for 1 minute, and then we'll continue with MOA and its alteration. Okay, 1 minute quick break. Okay, just closing my video. Don't go anywhere. We'll try to cover as much as possible today. Closing my video. We'll continue. Someone has a doubt with regard to signing of share certificates. See, share certificates have to be signed by any two directors. Okay. And if there's a managing director, the managing director or the chairman of the company will be signing it. Okay. So let's talk about MOA and AOA now. So talking about MOA and AOA, first we'll have to know what an MOA is, what an AOA is. MOAs are normally when an outsider is required to know about your company. In what name should I call you? Where should I come and meet you? What type of business can I have with you? How much of money can I give you? How much of money can I invest in your company? The earlier one, how much of loan can I give you? Okay, who are the subscribers of the company? So to know all these things, I would normally take my MOA and I will check, in which I will have my name clause, my situation clause, my object clause, my liability clause, my capital clause, and my subscriber clause, which are the six main clauses when it comes to a memorandum of association. And when it comes to the internal management of the company, where who can be the directors, what is the tenure of the directors, who can be members, how do meetings take place, how much of loan a company can take, what type of investments can these companies make. Okay, when there's a dispute, how this dispute will get resolved. All these informations which are happening internally within the company, you will check it in the articles of association. So articles of association is something which talks about the internal functions of the company, whereas the memorandum of association talks about the external functions of the company, which means the company's relationship with an external party. Okay, so now, can MOA be amended or the AOA be amended? Both can be amended. There's no problem. But when we are amending this one, certain things that we'll have to keep in mind is we'll have to always remember Companies Act is superior. Okay, Companies Act is superior. So whenever there's an amendment which is made in MOA or in the AOA, we'll have to ensure that the amendment is not contradictory to the provisions that are already mentioned in the Companies Act, which means that they normally say the dictators of law can be concentrated but cannot be diluted. So what do you mean by this? If you're going to make any amendment in your MOA or in your AOA, you can make it more stricter, but you should not make it lenient. For example, they're saying 21 clear days notice to be issued before you call for an annual general meeting. You cannot say no 14 days meeting, 14 days notice is sufficient. However, you can make that 21 clear days into 25 clear days or 30 clear days. That is possible. So which means that the dictators of law cannot be diluted, but it can be concentrated. So with this principle, you'll have to make amendments in your MOA or in your AOA. When we talk about amending the articles of association, it is a very simple process. Any clause of the articles can be amended. All the clauses of the articles can be amended. The process that involves is you call for a board meeting. The board of directors will take note of it and they will decide to make the amendment with the approval of the shareholders in a shareholders meeting. Then the notice for the shareholders meeting is issued within 21 clear days. Then the shareholder meeting is conducted. In the shareholder meetings, you will make sure the quorum is present, and after that you will propose that amendment, and if the members approve by passing a special resolution, which means that 2/3 of the majority of the members should approve for that transaction. After passing a special resolution, a copy of the special resolution along with the amended AOA copy will be filed with the registrar of companies within 30 days in form MGT 14. This is how articles are amended. This is a common process for any clause, and each clause separate resolutions you'll have to put. This is how you normally amend the articles of association. But when you come to the memorandum of association, each clause has its own way of getting amended. Let's start from the first clause, which is the name clause. How do I normally amend a name clause in a articles of association? First, I call for a board meeting. I decide, okay, let's change the name. Then I apply in run, because when I explaining about the incorporation process itself, I've told you, newly incorporating company, they should do through SPICE Part A. All existing company which would like to change their name, they have to do it through run, a reserve unique name, which is available in the Ministry of Corporate Affairs website, MCA website. So you have to go to run, and you will have, after the board meeting, if the board approves, then you will apply in run. And if the name is reserved, it will be reserved for the next 90 days, within which your incorporation, name change process should get over. So after the name is reserved, then you will call for a shareholders meeting. And after the shareholders meeting, we will say this name we've applied, it is reserved and kept. If you give your approval, in that case, we will change the name. If the members approve by passing again a special resolution, in that case, Form MGT 14 along with Form INC 24 will be filed with the Registrar of Companies within 30 days from the date of passing the special resolution. And if the form is approved, a new certificate of incorporation will be issued by the Registrar of Companies. Why new certificate of incorporation? Whenever I'm going to change my name, it may be for different reasons. For a private company to a public company, or there can be change in the industrial activity that I'm going to do. In all these cases, my SIN number also will change. That is why a new certificate of incorporation will be required for name change. So why am I first reserving the name and then going to the shareholders? Because conducting a shareholder meeting is normally an expensive process. We cannot keep calling the shareholders. After that, we apply for the name, and if it is not getting approved, it will be no point calling for a shareholder meeting. So first board meeting, then apply for name, get the name reserved, then call for a shareholder meeting, pass a special resolution, Form MGT 14 and Form INC 24, file it within 30 days, and your company name is changed. After the company name is changed, in your website, in your node, you should put the new company name. In the brackets, you should also put formerly known as so and so. I'm not sure for the number of years, how many years. Just check that once. As far as my remembrance, it is for the next 3 years. In the brackets, we should also mention that formerly known as, and the old company name also should be there. And make sure you change all your bills, vouchers, invoices, everything according to 1 year. Okay, Vaishak is saying it is 1 year. So for the next 1 year, it has to be wherever the company's name is published. And in the bracket, you should also put that formerly known as ABC Private Limited. Okay, so this is how basically your name change process happens. Coming to the next clause is your situation clause. When we talk about the situation clause, these can be broadly classified into 4 types. So one, shifting of registered office from within local limits, shifting of registered office outside the local limits, shifting of registered office from one jurisdiction to another jurisdiction, shifting of registered office from one state to another state. So shifting can be of any one of these 4 types. So let's see one by one. Shifting of registered office within the local limits. For example, I am having my registered office in, say in Chennai. Now, if I want to change within Chennai itself, I want to go to some other location. In that case, the shareholders are not much affected because they are coming to this area, they're going to come to that area, hardly 10-15 minutes travel. So shareholders are not getting affected because of this shifting process. So only board approval is sufficient. So whenever it is within the local limits, board approval, so call for a board meeting, get the board approval and file form INC 22 within 30 days from the date of shifting of the registered office with the registrar of companies. And all the proofs, whatever I said for the incorporation is only applicable even for shifting, along with the board resolution copy, because board has approved for it. However, whenever I'm going to shift outside the local limits, that is the second criteria. From outside the local limits, now I'm in Chennai, I want to make it to Kanchipuram, which is like outside the local limits. In that case, the shareholders have to travel a long time. So I have to go to the shareholders also, and I'll have to get their approval also. In that case, it will be a special resolution where board approval plus shareholders approval will be passed. Okay, and then INC 22 along with form MGT 14. Whenever there's a special resolution, form MGT 14 has to be filed. So in the second case, 2 forms, members approval is also required. Coming to the third one is from one jurisdiction to another jurisdiction. So what do I mean by from one jurisdiction to another jurisdiction? We all know that in two states there are 2 ROCs, in Tamil Nadu and in Maharashtra. Tamil Nadu have in Chennai and in Coimbatore, and Maharashtra has it in Mumbai and in Pune. So whenever there is a change from Chennai to Coimbatore or from Mumbai to Pune, it is within the state but from one jurisdiction to another jurisdiction. In this case, again, someone asked some time back, RD, where will his role come? When from one jurisdiction to another jurisdiction, RD will come into picture. You have to get the approval of the RD. So you will have to pass board approval, shareholders approval, make an application to RD, and then change. And there are a few more things, publications that you'll have to do, newspaper publications. Basically, you will have to mention one in the regional language, one in national language, one in English, saying that we are shifting our registered office from this place to another place. And you should also get the consent of your creditors. RD refers to regional director, who's above ROC, who's above the registrar of companies. Okay, so in your study material, it would have been even mentioned as the central government. Central government, the power is delegated to the regional director only. Okay, and from one state to another state, the same process will remain the same. Board approval, shareholders approval, RD approval, newspaper publications. Along with that, you will have to get even the sectorial regulators approval, whoever authorities you are connected to, their approvals, and you will have to get approval even from the state secretary, because the trade from his state is going out. So you have to get a certificate from the state secretary of that particular state also. In all these cases, from one state to another state, it will happen. So this is the process how you will have to change in 4 different ways for registered office shifting. Going to the next one is the object clause change. Object clause change is again a very simple concept where you pass a special resolution and file form MGT 14. Okay, once the object, if it is approved, you will get a new certificate of incorporation. Coming to the liability clause, again the concept here remains the same. Special resolution, MGT 14, object clause will get changed. The liability clause will get changed. Coming to the fifth clause is the capital clause. So whenever there's a capital clause amendment, you have to see two things. You have to see one thing, which is your fifth clause in the MOA talks about the capital clause, and in your AOA also there will be a clause which specifically talks about the capital. If the AOA says that as mentioned in clause 5 of MOA, then AOA need not be altered, because it is just saying as mentioned in clause 5. As and when we keep amending clause 5, automatically it means that it got amended even in AOA. But however, in certain cases there will be provisions which specifically mentions even in AOA, saying that the shares of the company, the authorized share capital of the company is 10 lakhs divided into 10,000 equity shares of rupees 100 each. In that case, I'll have to amend the articles also. I'll have to amend the MOA also. Whenever I'm amending the articles, it is a special resolution, and whenever I'm amending the capital clause of my MOA, it is only ordinary resolution. So for amending, when there's a special resolution for because even when I'm amending the MOA, I'll be filing even MGT 14 along with SH7. SH7 is for changing the share value. When I talk about increasing the authorized capital, it does not only increase the authorized capital, increase, reduction, split, consolidation, whatever I do with the share capital, I'll have to file Form SH7. So this is how I normally file. Again, within 30 days it has to be filed. This is how I amend my capital clause. And coming to the last clause of my MOA is the subscriber clause. The subscriber clause cannot be amended. Cannot be amended. So this is what my MOA is. So you would have seen what is ultra vires, which is beyond the powers of the law. That is what I said. Whatever the act is saying, you have to make your alteration within those particular limits. You cannot do something which is extraordinary, which is not allowed by the act, which will become ultra vires. Beyond your powers, you are not supposed to do, which is ultra vires transactions. Okay. So this is what about MOA in a way. And few were asking a lot of doubts related to insolvency and bankruptcy code. So I thought before we go to the next chapter, we could just try to cover a little bit about insolvency and bankruptcy code. Okay, because a lot of you were asking who's the financial creditor, what is the waterfall arrangement, and all these things. So let's see about this particularly. So this particular chapter, the name of this chapter is Corporate Insolvency Resolution Process, which the sole purpose of this IBC to come into picture is not to liquidate a company. It is just to revive a particular company. Whenever I'm going to talk about reviving a company, there will be certain schemes which are prepared for reviving these defaulting companies. The worst case, if these defaulting companies are not being able to revive, only in that case liquidation will be ordered. So this IBC is applicable to what all type of persons? It is applicable to all the companies which are registered under the Companies Act or which are registered earlier under the Companies Act. It is also applicable to statutory companies which where we saw it is registered by under any other act enacted in the Parliament. It is applicable to all the partnership firms and all limited liability partnership firms. It is applicable for any other body corporate which for the time being in force was incorporated by the central government. It is applicable for normal partnership firms. It is applicable for individuals. So basically this IBC is applicable for all type of people. Okay. And when I can start a proceeding against this IBC is, earlier it was 1 lakh. After this COVID has come, they've given relaxation where they've made the limit where there's a default of more than 1 crore of payment. In that case, I can file a suit against under IBC. Okay. Who can normally initiate? Who can make a petition, make an application to the National Company Law Tribunal? So National Company Law Tribunal only hears all these things. Who can make this application? Is application to initiate CIRP, Corporate Insolvency Resolution Process, where we are saying this corporate is insolvent, give some resolution process to revive it or then close or just close it. So that is only called as CIRP, Corporate Insolvency Resolution Process. Who can make this application? It can be the financial creditor, it can be an operational creditor, it can be the operational debtor himself to initiate this process. So who's a financial creditor? The term financial itself refers to the person who has financed you, which means that banks and other financial institutions. Who's an operational creditor? In the operations, you're liable to pay me, which means that I would have supplied some services or goods to you and you're yet to pay me. In that case, I will become the operational creditor. Okay. By virtue of doing business, you're yet to pay me, operational creditor. By virtue of pure loan, financial creditor. Or the corporate debtor itself, the person who has taken the money but has not repaid, is the corporate debtor. So any one of these three people can initiate a CARP, corporate insolvency resolution process. Now we will see in what cases financial creditor can make a complaint, in what cases operational creditor can make a complaint. When we talk about financial creditor, if there is a default that has occurred, the financial creditor, either by himself or jointly along with any other with others, they can initiate this process. The CARP application should be enclosed with certain documents where it shows the records of default recorded in the information utility, the name of the resolution professional, and saying this there's no misconduct, and any other information as may be accepted by NCLT. Okay, so when I talk about information utility, what do I mean by information utilities? Whenever banks or financial institutions give some loan, there will be a common database which is managed by the central government, which is called as the information utility, where all the loan related data are mentioned there. So if you have given him the loan, you would have entered it in the information utility also. No, give me an extract of it. So that copy, along with a resolution professional. Who can act as a resolution professional? A company secretary can act as a resolution professional, a chartered accountant, a cost accountant, or an advocate, who are having more than 10 years of experience and who have cleared the insolvency and bankruptcy examination that is conducted by Insolvency and Bankruptcy Board of India. Okay, they can act as resolution professionals. So they, at the time of making the petition itself, resolution professional also should be mentioned. And the adjudicating authority, who is the NCLT, within 14 days will either accept or reject the application based on the evidences that are produced. And if it is going to accept, in that case, the CARP process is set to be started once it is accepted. And once it is accepted, within 7 days, NCLT will communicate it to the person who has made the application, saying that yes, we have approved it, you can start this CARP process. This is a financial creditor will normally approach. When it comes to an operational creditor, which means that I would have supplied some goods or services, but you are yet to repay me. When we talk about operational creditor, the process is a little different. First, what the operational creditor is supposed to do is he has to send something called as a demand notice. Demand notice to the concerned party who's yet to pay us, and you'll have to give him 10 days time, saying that, see, you're yet to pay me, you better pay me back, or I'm going to file an insolvency case against you. 10 days time is given, and within this 10 days, the person who has received the notice should give a reply. So what kind of replies that he can give is, there's already a dispute in this payment. Until the dispute, and there's an arbitration or some proceedings which is going on, until that is over, I will not make the payment. Or I should say, I've already made the payment. See, this is the online transfer receipt, or you have encashed the check that I've given. See, I have a proof for it. One, I should say why I am not paying, or I should say I am paying. Okay. If I don't reply, or if my reply is not satisfactory, after the expiry of 10 days, the operational creditor can make an application to NCLT, and the same process will follow. I'll have to make evidences along with the resolution professional, and the NCLT, if it accepts, from that day onwards, the CARP process will start. So, until what is the time to the CARP process? Insolvency is basically very time bound. So, when I talk about time bound, what is the time duration normally within which the CARP process should get completed is within 180 days. However, with the approval of the committee of creditors, whenever it is a financial creditor, there will be a committee of creditors which will be formed, where I'll explain you in some time. With their approval, it can be extended for a further period of 90 days. So, which means that 180 plus 90 days can be the maximum period. And when the CARP process basically starts, all pending cases, all litigations, all execution of projects, and all the assets of the company should not be transferred or alienated or sold out or anything. It's everything which is related to the company will stay still, and only the CARP process related work will happen. Okay. I was talking something about the resolution professional. What will this resolution professional basically do is, he will come to the company, he will appoint a valuator. Again, a valuator is a person who has cleared the valuation exam conducted by the Insolvency and Bankruptcy Board of India, who has at least 3 years of experience as a company secretary or a cost accountant or as a chartered accountant. So this resolution professional will basically call a valuator. He'll ask to evaluate that company, and he will also check whatever is the dues that are there for the company. He will invite others also to claim if they have any dues, and he will make a list of all acceptable dues, and he will see what is the value of the company, how much dues is that, whether I'll be able to settle, or can I make any other plan. I can even, as a resolution professional, I can even go to public asking them for their opinion. Give me some idea how to revive this company, which is called as the resolution plans. I can collect all these resolution plans, and after I get all acceptable claims with all the creditors, mainly of financial creditors, a committee of creditors is formed, who's called as the COC. This committee of creditors will have, once they are formed, they will have the ultimate authority over the RP itself, over the resolution professional itself. Suppose if the CRC is not satisfied, they have all the powers to even change the RP. So what this RP will do, after he gets the resolution plan, he will come and give it to the COC, saying that I'm planning to revive the company like this. Is this okay for you? If the COC approves, the resolution process will start. If the COC is not satisfied with any plan, then the liquidation plan will start. Once the liquidation plan once it is started, the RP, the resolution professional, will become the insolvency professional. Now, when after that, he will start selling all the assets, liquidating all the assets, and he'll be settling everyone's claim. Whenever I'm going to settle everyone's claim, I will have to give priority. Who should I pay first? Whom should I pay second? And all these things. So this priority is called as the waterfall arrangement. On whom does the water fall first? Water here is basically represented to the money, the payable that is given. So waterfall arrangement basically refers to on whom does the water fall first. Okay, to whom do I settle first? Okay, so they've given an order in which the money has to be settled. So the first expense that has to be met with this in the waterfall arrangement is the insolvency resolution process itself. Okay, the RP is doing all these activities now, so the amount that is involved in all these activity, the insolvency resolution process cost. Second one is the following debts, whatever I'm going to say now, will be ranked equally. The workmen dues for the past 24 months and the dues that are payable to the secured creditors who has relinquished their right, saying that I have security with me, but I'm not going to exercise it. I relinquished my right. I give it back to the company, to the RP, let him liquidate and give it to me. So I relinquished my right. I'm a secured creditor, but I have not exercised my right. I relinquished my right. In that case, I will be treated in the second criteria along with workmen dues for the past 24 months. Coming to the next one is employee dues for the past 12 months. Coming to the next one, secured creditors. Coming to this next one, all government dues along with the secured creditors who has not relinquished their right. Coming to the next, all remaining debts and dues. Coming to the next, preference shareholders. Coming to the next, equity shareholders. This is what is waterfall arrangement. In this, so which means that the equity shareholders will get last. After settling the CIR pay cost, after settling the workmen dues, secured creditors who has relinquished their rights, employee dues for the last 12 years, sorry, last 12 months, secured creditors who has not relinquished their rights, central government, unsecured creditors, central government dues, and then comes secured creditors who has not relinquished their rights, remaining debts and dues, preference shareholders and equity shareholders. This is the process, this is the flow in which the waterfall arrangement will normally take place. Okay, and with this IBC is over. Now let's discuss a little bit about striking the names of a company. So any doubts, if anyone has got, I'll just quickly see for say 1-2 minutes, and then I'll go for striking the name of a company and a dormant company and winding up of companies. This will be the next. Act is saying 21 days and AOA is saying another time for sending notice. Which one to be followed? If AOA is saying more than 21, follow the AOA. If AOA is saying less than 21, then follow the act. Can we get new certificate for change in address? New certificate of incorporation will be issued only when you are shifting your registered office from one state to another state. Because in your SIN number, you will the 21-digit number. You will also have the state in which you belong to. So when it's going to change from one state to another state, your SIN number will change. Only in that case you will get a new certificate of incorporation. In all other cases, you will not get a new certificate of incorporation. My purpose of doing business, whether it can be changed. Yeah, it can be changed. That is what is changing the object clause. Why cannot subscriber clause be amended? Can you re-explain shifting from one state to another state? If I re-explain now, it will take a long time. This will be anyways uploaded in the YouTube. You can see it once. See why it can't be amended. See, everyone will have their own school of thoughts. I have no idea on why it can't be amended. My assumption here is when we talk about the subscriber clause, the company is being registered with those members, and after that anyone can become a member and the shares can be transferred to another person. So by way of simple transfer, the subscribers can get changed. So we need not go to the MOA. The only thing that comes to my mind is this. I have no other reason to think apart from this. What is meant by doctrine of indoor management? So when we talk about doctrine of indoor management, for example, I'm a practicing company secretary. Someone has come to me and they're saying that we are going to appoint directors in the company. I will say them, this is the process that is involved. Get the shareholders approval, give me the resolution copies. I will do the filing and give it to you. They're saying, okay, they're coming after 30 days and they're going and they're telling me we've passed all the resolutions. We've got the shareholders approval. These are the resolution copies. These are the minutes copies. Please proceed with the appointment of new directors. I'm also appointing the new directors, and then a few people are coming and they're creating trouble with me, saying that the meeting was not happened. Why did you file the appointment? So what kind of shelter that I can take is doctrine of indoor management. I, as an outsider, don't know what is happening inside your company. Based on the documental evidence that you're giving it to me, I blindly believe that yes, that would have happened, and I have done some act. So if that was not done, I am not liable. So an outsider is getting protection because it is not a public document. Your minutes book is not a public document. However, if it is your MOA, AOA, or your financial statements, it is a public document. If due to my negligence or omission, if I have not read it, in that case, I will be liable. So doctrine of indoor management normally gives a protection to an outsider from the company for matters that are discussed inside the company. Okay, Kalyani. Can it be said that IBC process to be as a mediation process? It's not basically a mediation process. It is a process which would help a company to revive. It is a revival process than a mediation process. How does the professional ask for resolution plan from public? Where do they publish and what details do we publish? Is there any such case which can be seen on the internet or on the website or on the invitation for public views? It can be asked. It just go to Insolvency and Bankruptcy Board of India website. On their homepage, you will have public invitations for resolution plans. IBBI website. Okay. It's publicly available. Any interested party can give a resolution plan to it. Okay. So when secured creditors do not relinquish their right, the charged assets remain available exclusively for them. Yeah, it will be exclusively for them. Financial debt is when I take money from a financial institution and if I don't repay it. Financial debt. Operational debt, financial debt. I've already explained. Moratorium is to put a pause for everything. You just press the pause button and keep everyone on pause. That is called as a moratorium, which means that after that you can't sell the assets, you can't alienate the asset, you cannot transfer the assets, you cannot issue, you cannot file new cases, you cannot continue the existing cases. You can, if the case is over and if the order has come also, you cannot execute the order. Moratorium is basically putting a full stop for keep not a full stop, putting a pause for everything. Okay. The secretary, I mentioned the chief secretary. When we are shifting the registered office, you have to get it from the chief secretary of the concerned government. Doctrine of indoor management will be applicable to a whole-time CS as per your example. It is not applicable to whole-time CS. Whole-time CS is an insider. I am talking about an outsider, a practicing CS. I don't know what is happening inside. A whole-time CS still can check, can view the minutes book because he's only preparing the minutes book. I'm talking about an outsider, practicing CS. Okay. So let's continue again now. I'm closing the chat. Now let's see a little bit about striking the names of a company. So what do I normally mean by striking the name of a company? When who can do this? Striking the name of a company is basically discussed in section 248 of the Companies Act. It can be either done by the registrar or by the company itself. When a registrar will do, whenever a company is inactive for 1 year from the date of incorporation or for 2 continuous years, and if that particular company has not applied for dormant status under section 455, in that case, the ROC will send a notice to the company in form STK1, asking reasons that you are not doing any business from 1 year from the date of incorporation or for 2 continuous years. Tell me the reason why I should not strike the name of your company, which means that remove your name from a register. And they will give a time period of 30 days within which the company has to reply. If the company fails to reply, in that case, the registrar can go ahead and they can strike the names of the company. However, this is point number 1. Second one is, when can a company apply for voluntarily strike the names of the company? 2 situations: when there are no assets and liabilities in the company, and when there's a special resolution which is passed by the company, or if 75% of the consent of the members is given. In that case, the company can file an application in form STK2 to ROC to strike the name of the company. Okay, so ROC will send form STK1. If you don't reply properly, they will remove the name. Company also can voluntarily do if they don't have assets and liability, and or if by passing a special resolution, or after getting 75% consent of the shareholders. In form STK2, I can file this striking the name of the company. But there are certain type of companies whose name cannot be striked off. So if I want to get striked off, I should have nil assets and liability. So if I have liability, then I have to go to winding up. I can't do it through strike off. Okay. There are certain type of companies which cannot be striked off. Example, listed companies, companies delisted due to non-compliance of listing regulation. Vanishing company. Vanishing companies refers to those type of companies whose directors are non-traceable. Companies where inspection or investigation or some action is still pending. Companies which have received notices from the courts for serious fraud investigations which are happening. Companies against which there's any prosecution or offense that is pending still in the court. Companies whose application for compounding is pending before any competent authority. Companies who have accepted public deposits and who has any outstanding defaults for repayment. Companies who have charges or whose charges still pending for satisfaction. And Section 8 companies cannot be striked off. These are all type of companies which cannot be striked off. Okay. Coming to the next one is, suppose if I get striked off, what can I do? I can revive my company. So I can revive a company by making a petition to the National Company Law Tribunal under Section 252 of the Companies Act, where even though my company is striked off, my company will still be alive for 20 years. So what do I normally mean by strike off? It is just like going into coma stage. I don't know just what is happening. Okay. I cannot do any activity. but I'm still alive. I'm in coma stage. So there is a chance to revive myself within 20 days, 20 years. For the first 3 years, any interested party can make an application to revive this company. After 3 years gets lapsed, the limitation of time limitation is over of 3 years. Only the creditors, the shareholders, uh, or the company, or the workmen, four persons, the company, the workmen, the shareholders, or the creditor. Only these people have the right to make an application to revive the company under section 252 by making an application to the NCLT. And NCLT, after hearing it, if they feel satisfied, they will pass a order copy to resolve the to revive the company, and that order copy will be filed with the registrar of companies, and after that the company will get revived. This is how you normally revive the company. There are certain situations when I'm explaining about striking the name of the companies. What did I say? Which has been inactive for a continuous period of 1 year from the date of incorporation, or 2 continuous years. In that case, the company can be striked off. And who has not applied for status of dormant status under section 455. So what do you normally mean about dormant companies? So these dormant companies, I've already explained initially self. Companies who are inactive for 1 year from the date of incorporation or for 2 continuous years, and where there's no significant accounting transactions, you can apply for a dormant status under section 455 in form MSC1. Okay. And if the ROC is satisfied, they will give a certificate called, yes, you are a dormant company, in form MSC2. And even though I am a dormant company, every year I am supposed to file certain returns, annual return, which will be filed in form MSC3. And even the maximum time period up to which I can be a dormant company is for 5 years, after which I'll have to become an active company. The application to become an active company will be made in form MSC4. And the registrar of companies, on satisfaction, they will issue an active company certificate in form MSC5. So MSC1, 2, 3, 4, and 5. However, there are certain conditions for companies to get this dormant company. Again, like strike off companies, certain type of companies cannot apply for striking off. There are certain type of companies which cannot apply for dormant status also, where companies, there is no inspection or inquiry or investigation that has been taken place, no prosecution has been initiated, companies which has no public deposits which are being outstanding, companies which has no outstanding loans or secured or unsecured. In case there's an unsecured loan, after getting the concurrence of the lender, form MSC1 can be filed, and where there is no dispute in the management of the company, there's no any government dues which are there in the company, there are no any workmen dues in the company, and whose securities are not listed either in or outside India. And all these type of companies cannot apply for dormant status. Okay, so with this, your striking off and dormant is also completed. Moving on to the next one is the winding up process. Any doubts that you would like to ask so far? Where is it? Big doubts you people have typed and kept. I forgot to carry my water bottle today. Feeling thirsty. Sir, if a company is having below 5% shareholding in a private limited company, can the parent company buy back the shares? Company is having 5% of shareholding in a private limited company. No, the private company, the parent company cannot buy back its shares. It's not possible. How does ROC come to know a company is active or inactive 1 or 2 years? See, how will I say I'm active or not? By filing returns. So I'll have to file my returns every year, and return filing is online filing. So as soon as I make a return filing, automatically it gets updated in the database because it's all online. But just seeing the list of companies which have filed their returns properly itself, we'll be able to identify whether you're active or inactive. If you're inactive, you would not have filed your returns. So like this, the ROC will come to know. I've explained what is the process to revive the company. Application for revival of company after strike off by shareholders, company employees or creditors can be done. What is the difference between shareholders and the company? Shareholders means, I've already told you, the members of the company. Company refers to the board of directors. At the time of reviving the company, the directors signed the application before NCLT. In this case, company is still an independent entity. Then what is the provision that resolution is favor of director or signing authority? Kapil, I'm not able to understand your question. Company is having liability and asset, and the shareholders wish to strike off the company. Can the shareholder take over the assets and liability and strike off the company? If yes, please, how? See, how shareholders can take over the assets, but how they can take over the liabilities? They have to pay the liabilities. If assets and liabilities can be exhausted, okay, the main thing is liability should be paid back. In that case, strike off can happen, the normal voluntary way of doing it. Is it necessary to go under winding up before having strike off? If you have liabilities, then winding up only should go. If you have nil assets and liability, then you can go for strike off. Both are mutually exclusive. STK2 is for voluntary strike off. When a company wants to get striked off voluntarily, it will just pass a special resolution of 75% of the concern of the members, and they will make an application to the ROC to strike their name off in form STK2. STK2 is a E-form. Can you explain 55 redemption of preference shares? Not my subject, Manoj. We'll just discuss whatever is this subject related. We'll go out of the topic. Okay, so there are no more doubts. So let's continue with winding up. One second, my battery is low. I'll just keep it on charge. Okay. For signing any application or litigation before the authorities, the signing person gets authority through resolution. In case of reviving, whether the directors get such resolution. See, when you're going to revive a company and the company, for example, has been inactive for 10 years, and then after that, if you want to revive the company, what would basically happen is the company, when I refer, the maximum number of directors will sign the application to revive the company. Okay, so resolutions and all will not be passed in this case, but the maximum number of directors who are present, they will sign it and give. Or if you're going to keep a resolution also, it will still be valid. But it will not, resolution is not something only where the company, only if it is alive, you can pass a resolution. Resolution is saying that everyone together we've decided and giving powers to someone on behalf of us, he will sign it. Okay. But whenever we make these type of applications, I would prefer all the directors to sign and give it. Okay. So, just closing the chat. Let's talk about winding up. So winding up is a stage where the life of the company is coming to an end and the properties are administered for the benefit of its members or to the creditors. So what will normally happen? We will sell off all the assets, and whatever money we are getting, we will either settle the creditors or give it to the members. That is why it is either administered for the benefit of the members or the creditors. Here, a liquidator is appointed who is called as the insolvency professional to collect the assets, to repay the debts and distribute. So whatever we saw in the liquidation process, collect whatever claims are there, evaluate the company, and to settle, for which purpose the liquidator is appointed. Solvent or insolvent companies both can apply for winding up process. Winding up is normally said to be as the process that is involved, and dissolution refers to the end result of this process. Okay, and when we talk about winding up process, the process for winding up of companies are provided under Chapter 20 of Companies Act 2020. There are two modes of winding up, which is winding up by way of a tribunal, which is also called as a compulsory winding up. Second one is voluntary winding up, where there is no tribunal intervention in the company. So there are certain circumstances where the tribunal will pass an order to strike the name of a company. What all cases tribunal will pass an order to make a to wind up the companies as per section 271 of the a company may make an application to be wound up for any one of the following reasons, like after they pass a special resolution, if the company has acted against the interest and sovereignty and integrity of India on an application by the registrar or any other authorized person of the central government, if a company is defaulting for a continuous period of 5 years, and if if for any other reason that the tribunal may feel just and equitable. In all these cases, the tribunal may pass a order saying that, okay, fine, go ahead and wind up the company. When, by passing a special resolution, when a company by itself acts against the integrity and sovereignty of India, if I don't file returns for a continuous period of 5 years, if an application made by the registrar or by the central government or any other just and equitable matter. Okay, so who can normally make a petition? Who can normally make a petition to the tribunal to wind up? One, the company itself can make along with the statement of affairs, which means the board of directors can make. Second one, any contributory can make. When we talk about the contributory, it refers to the shareholders of the company or the creditors of the company who were also the previously the shareholders of the company in previously in past 18 months. At least if for 6 continuous months, if I was a shareholder in the company, I will be still called as a contributory, or a combination of both, or the ROC or any other person authorized by the central government can make a petition. So a copy of the petition shall also be filed with the registrar, and the registrar also is supposed to give his views to NCLT whether, okay, go ahead and strike the name of the company, or no, don't strike the name of the company. So they'll have to also give their views. Okay, after getting this petition, what will the tribunal basically do? So all these are basically compulsory winding up. From the time I want to wind up the company, everything tribunal will decide. Okay, where it comes to voluntary winding up, everything shareholders will decide. Only the last order copy will be issued by the tribunal. Okay, so now whatever we are seeing is compulsory winding up. Under section 273 subsection 1, the tribunal on receipt of the petition may pass any one of the following orders, like it may dismiss with or without cause, it can make an interim order as it may deem fit, it may appoint a provisional liquidator till the final order has come, order to wind up the company with or without the cause, or any other order it may deem fit. With or without cause, basically when you make an application, you have to make some payment to the court, because they are spending their time and resources to hear to your case. So that is cost. It can be with or without cost. And after you get, once the court accepts, admits the application, an order under this section should be made within 90 days on receipt of the petition. Okay. Who will normally be the liquidator? A person who has cleared the IBC exam. I told you already who will be an insolvency professional. All these things are specifically dealt in Chapter 20 of the Companies Act. Coming to voluntary winding up is not specifically discussed under Companies Act. However, it is discussed under Insolvency and Bankruptcy Code, Chapter 5 of IBC, deals about voluntary winding up. So where it says that any corporate person can liquidate itself voluntarily. If a declaration by majority of the directors is given in the form of an affidavit, The audited balance sheet for the last 2 years is submitted and evaluation report is given by a registered valuer. What will be this declaration given by us saying that we see these are all the liabilities that we have, and in future if any other surprise liability comes also, we indemnify the loans that are against it. So they take all in charge and they wind up the company. So they have to make all these declarations to the registrar of companies, and within 4 weeks from the date of the directors declaring this affidavit, you'll have to call for a shareholders meeting and pass a special resolution. And in the special resolution, you'll have to get at least 2, and after the special resolution is passed, you have to also call for a creditor meeting. You'll have to get the creditor's approval also, but 2/3 of the creditor also should approve. Okay. Once all these things are obtained, within 7 days, I'll have to inform to the registrar saying that shareholders approval also I got, creditors approval also I've got. I'm going ahead with the voluntary liquidation process. The voluntary liquidation process is deemed to be starts when shareholders and the creditors give their approval. Once the affairs of the corporate entity is completely wound up, what this liquidator will do, then he will go to the adjudicating authority, who is the NCLT, saying that I liquidated the entire company. Please give a order copy to saying the company is dissolved. And within 14 days, the corporate person will have to file that order copy with the ROC, saying that see, NCLT has said that we are wound up. So just take this also into your consideration. We are no more in existence. We are dissolved. So this is how voluntary liquidation takes place. Here, everything the members and the creditors will decide, and then finally, after everything is liquidated, the liquidator will make a petition to the NCLT, who is the adjudicating authority. And after that, that order copy will say yes, the company is dissolved, and that order copy will be filed with the ROC within 14 days. And ROC will remove the name of the company from its register. So this is how a company will normally be wound up. So yeah, there's been some doubts that have been asked. See, exemptions for striking the name of a company. Companies, the listed companies or companies which are suspended from listing, companies whose there are some prosecution litigations pending, who there's some investigation pending, who has public deposits outstanding, companies which have charges in their name, companies where there's condemnation of delay or serious fraud investigation, all these type of companies, vanishing companies or a Section 8 company, all these companies cannot be striked off. Okay. And sir, is it approval of 66% or 75% for committee of creditors? Earlier it was 75%. Now they've made it as 66%. There was an amendment which was made in 2018, after which Rahul, it is 66% now. Sir, this adjudicating authority is not getting clear. Can you elaborate? Adjudicating authority is NCLT. After winding up, company can be revived. After winding up, it cannot be revived. Only striked off companies can be revived. Can employees file winding up in NCLT if the employee fails to pay his salary? No, it cannot file a case. That is what we saw. Who can file a case? The company can file, the contributories can file, ROC can file, or the central government can file. Employees can't file. Sir, winding up and dissolution have same meaning? No. Rutuja, it is different. Winding up is basically the process that is involved. Dissolution refers to the end result of that process. Okay. What are vanishing companies? Vanishing companies are those companies whose directors are non-traceable. Okay, are vanishing companies. 66% with relation to what did you say, sir? See, before we saw about winding up, we were seeing about insolvency in bankruptcy. In that, the resolution professional will be constituting the committee of creditors. In that committee of creditors, whatever decisions are taken by the committee of creditors, at least 66% of the creditor members have to be should agree to it. So someone from Dell, name not showing, Dell only showing. So 66% we were referring to them. Adjudicates means who gives the decision, who has the authority to give this, to make orders, pass orders. Company cannot be revived after dissolution. Yes, yeah, rather it cannot be resolved. So now what we'll do is we will just take a small break for 1 minute, 2 minutes, and then again we will continue. Okay, I've already said what is a vanishing company, Durga. Okay, so we'll continue after 1 minute. Okay. Okay, we'll continue. Under this particular winding up provisions, the employees doesn't have any right to make a application to wind up the company. We'll continue. What happened to everyone? Sleeping, huh? After 20 years, the company will get dissolved. What happens after 20 years after strike off? The company will get dissolved. Fine. Yeah. I know break is too short, but today is the last class now for me. I just want to do a recap of everything, whatever we've discussed so far. Okay. That is why break is too short. Even I am tired actually. Uh, the next thing that we're going to see is the different types of organizations, business organizations, which normally refers to the sole proprietary, partnership, HUF, and multi-state cooperative societies. We've already seen about this a lot, so let me not discuss too much on it. I'll just cover the features of these four types of organizations. Like when we talk about the sole proprietary, majority of the small businesses are sole proprietary. The ownership, the management, the control, everything lies with the same person. Business and the proprietor are one and the same here. All the assets of the business is the assets of the proprietor. The liability is unlimited, so that even the personal assets of the person can be attached, and there's no separate registration that is required to be taken when it comes to a sole proprietary business. However, a certain other registrations such as however, there are certain other registrations such as GST or MSME or SSI. These type of things are required to be taken. Okay, so yeah, on your request, there's been someone who said that, sir, this is a little bit easy chapter, so why don't we go to financial institutions? Okay, so let's go to NBFC chapters then. Financial service organization and its registration process. This is actually a very big chapter. Let's see it as quick as possible. Financial service organizations. Okay, there are a few doubts where others are also asking about HUF. Let's quickly see then. Let me continue after this is what is about sole proprietary. There's no special registrations that are required. Then comes the partnership. Partnership is an association of persons who has agreed to come together with and to share their financial resources and managerial ability to run business and to share profits in an agreed ratio. The business can be carried out by all or by any one of them on behalf of all. The maximum number of partners that a partnership firm can have is 20, and the minimum is only 2. There's no set provisions that the contract between the partner and the duration has to be so and so. The terms and condition, the contribution, everything will be as per the partnership agreement. However, the liability here again will become it's unlimited liability. And how do you register a partnership firm? When we talk about registering a partnership firm, it has to be done in the sub-registered office in the registrar of firms. So decide the name where it should not represent or patronage, should show any patronage with the government unless it is allowed. It has to be registered at the registrar of firms in the area where the business is located. A partnership deed has to be transacted on a stamp paper. Partnership deed will be basically on a stamp paper, which the stamp duty will be decided based on each and every state that it is going to be registered at. List of documents that has to be submitted to the registrar is form 1, which is an application, filled affidavit, a partnership deed, and the proofs of the owners. According with all these things, you will make a filing about you will register your partnership deed. Coming to HUF, there's no specified law that would govern HUFs. However, in general, we'll have to read the Hindu Succession Act and the Income Tax Act when we are going to talk about HUFs. The members of the how to become a member in a HUF only by virtue of a birth or by marrying a male person in the family, you can become a member in the HUF. There are two types of HUFs, schools of HUF that are functioning in India. One is the Dayabaga and the other is Mitakshara. Dayabaga normally refers to those kind of entities where women are basically given equal rights along with men. However, recently there's been cases which have come which have given even women equal chances in their in the property, and the entire operations is held by the Karta, and his liability is only unlimited, where the other members, the co-person's liability is limited. Only Karta will make decisions and his liability is unlimited. And the name of the HUF should end with the Karta's name. For example, if the Karta's name is for example, if the Karta's name is Santosh Kumar, then the name of the HUF should end with Santosh Kumar HUF. Okay, so what is the registration process that is involved for HUF? We have to create a deed which has to be executed on a stamp paper. The eldest male will become the Karta over here. The name of the HUF will have the Karta name followed by HUF. Also state the capital in which the capital amount for the HUF. A declaration is also to be provided by each member that the Karta has the ultimate authority to take decisions, and the accounts and transactions will be under the control of the Karta. A rubber stamp has to be prepared in a rectangular shape, and it has to be affixed in all the documents of the HUF. It has to be notarized, and it has to be you can just apply for a PAN card and open a bank account with that agreement. So you need not take this agreement and get it registered anywhere, but there should be an agreement. Using this agreement, just like partnership deed, where registration is not mandatory. Even for HUF, you don't go anywhere and get it registered, but there should be a agreement that is executed with the partnership thing. On multi-state cooperative societies, I've explained you sometime before itself. How do we normally register multi-state cooperative society? So I'm not saying about it. I'm skipping multi-state cooperative society. Coming to formation and registration of NGOs, there are totally 3 different types of NGOs. If I want to do business for not-for-profit in India, I can do it in any one of these 3 forms, which is a Section 8 company, or as a trust, or as a society. Certain features about a Section 8 company, where a Section 8 company has its objects for promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any other such objectives. The intent to apply for you can earn profits, but then you should not it should not be distributable profits. You should not issue dividends. The name of the company will not end with private limited or with the word limited. It will just end with foundation, confederation, council, and all these type of words. There's no minimum requirement for minimum capital requirement for registering a Section 8 company. Minimum 2 directors are required. Just like a private limited company, the membership, when it comes to the membership, separate legal entity concept still exists here. There's no stamp duty for registration. Any changes that has to be done in the MOA and AOA should be done only by getting the central government approval. And if the central government feels they are not doing the business properly, the incorporation process is all the same, apart from the extra license ones what they get, and this license is given by the central government, which is called as a Section 8 license. If the central government feels you are not running properly or you are misusing your license, then they have all the powers to revoke the license that is given. Okay, and when Section 8 company is getting closed, I've already told you the assets have to be given to another Section 8 company, or it has to be transferred to the Insolvency and Bankruptcy Fund formed under Section 224 of Insolvency and Bankruptcy Code 2016. Okay, suppose if I do any violation in handling the Section 8 company, then the penalty for the company will be rupees 10 lakhs up to 1 crore, and for every officer who's in default, with imprisonment up to 3 years, and with a fine which may not be less than 25,000, which may extend up to 25 lakhs. Okay, this is what is a Section 8 company. The registration process is same as a company, and we've already seen what a trust is, what a society is. So I'm just skipping this because we've explained about these 2 more. So you can also see the recorded classes which are there in the YouTube. So let me quickly go to, we'll do one thing. There's a half an hour left. I will start taking up your questions. all related doubts, whichever is there in the portions, whatever I've covered, you can start asking me. The best thing that I can do is I can start answering your questions so that students who are attending this class will not be disappointed. Your questions can be answered. Okay. So anyways, the recorded versions are available in YouTube. You can check them once. I'll start answering your questions. Okay. 1 second. Okay. The remaining portions will be handled by another faculty. What about asset reconstruction companies? Asset reconstruction companies. Yesterday, I think yesterday I was explaining about asset reconstruction companies, because there will in financial institutions, what will happen is the banks will normally give loans, and they will give loans, and the money will have to go in a rotation. At sometimes what will happen is when banks give big loans, it will go and get blocked with a particular person, with a particular borrower, and he'll not give the money back to us. In this particular time, what will happen is the money which is yet to be received by the banker will be treated as an asset, which will on the assets it will be mentioned as receivables. So this particular asset will become non-performing assets. So these non-performing assets will be purchased by these asset reconstruction companies, where they will buy it from the banker. For example, if it is 100 crores, they will buy it for 80 crores and say the remaining 20 crores is our profit. We will try to collect all the 100 crores from the borrower, and the risk what we are taking, the 20 crores will be our profit. So these asset reconstruction companies will help the banks to release the distressed assets from their balance sheet. Okay, so these are called as asset reconstruction companies. What are the types of NBFCs? When we talk about NBFCs, they can be broadly classified into 10 types of NBFCs. One, which is the asset finance companies. The second one is the investment companies. The third one is loan companies. Fourth one is infrastructure finance companies. Fifth one is systematically important core investment companies. Sixth one is infrastructure debt fund, non-banking financial companies. Seventh one is non-banking financial companies, which are MFIs, microfinance institutions. Eighth one is non-banking financial companies, which are into factoring business, which is just like your asset reconstruction companies. Mortgage guarantee company and non-banking financial companies who will act as a holding company just to form another financial institutions. To quickly see about what each type, all these 10 types, we will quickly see what is it. Asset finance companies are those companies which would normally finance huge assets, like financing of physical assets. Okay, like what type of assets they normally finances? Automobiles, tractors, lathe machines, generator sets. So big machineries they normally finance. These are called as asset financing companies. Second one is investment companies, whose core business is to invest in the securities of any other company. Loan companies are those companies, apart from the loans that are given by the asset finance company, any other loan that is given by a non-banking financial company, it will be termed as a loan company. Then comes the infrastructure companies. These are basically deployed, where 75% of their funds are deployed to fund infrastructure based companies. Then comes systematically important core investment companies, where when we talk about investment companies, sometime back I was telling 50-50 test has to be passed. When systematically core investment companies comes, 90% of the assets should be invested only in investment assets, and 90% of their income should be derived from the total assets of these companies. Infrastructure debt fund, these NBFCs are basically are formed only to maintain a reserve which is called as the infrastructure debt fund, which will be contributed by infrastructure finance companies, and they will in turn they will be funding to the infrastructure companies. Then comes non-banking financial company in microfinance companies, where in rural areas to give small loans, where if it is in rural area, the maximum loan that you can give is 1 lakh, and semi-urban areas, you can give up to 1.5 lakh per person without collateral. Okay. And the repayment tenure and all should not be less than 24 months. There's a condition. So in order to provide loans at rural areas, MFIs are normally preferred. Then comes non-banking financial companies into factoring, just whatever I explained for asset financing companies. Same concept is applicable even for factoring companies. Mortgage guarantee company, if I'm going to a bank, they're going to ask me for collateral. So these mortgage guarantee companies, what they will do, they will give guarantee to me. And for that, I have to give them some service charge. These are called as mortgage guarantee companies. Then the last one is NBFC, non-operating financial holding companies, which are normally, these companies are solely formed to form another company, because companies can be member in another company. These companies will just hold shares in another company by which a new bank can be incorporated. So these are all the different types of NBFC companies. Okay. Okay, Rahul, this is what I've shortly explained. Different types of NBFC companies. So there is HUF deed, and on the base of deed, birth and marriage, the member are added. Then how the later member get added? Later member cannot get added. Later member can get added in a HUF only by birth or by marrying. In no other way membership can be added in HUFs. Who is partner by holding out? What it means, how it means. See, I am having a partnership business, and I am saying, for example, the ex-governor of RBI is my partner. Okay, or some great personality. I'm saying he's my partner just so that I will get more business. And that other person is also knowing that I'm using his name, but he's silent. In that case, if there is any liability that is going to arise in the firm, even that partner will be liable. That partner is called as partner by holding out. Okay, he is knowing but he is not objecting, so he is called as partner by holding out. And Rahul, actually NBFC chapters are easy only. Just study calm, you will be able to understand. Nidhi companies. Can you explain Nidhi companies? See, Nidhi companies are those type of companies whose main objective is to accept deposits and to give loans. And there are certain kind of things that it has only with members I can have do this business. The minimum capital that is required is 5 lakhs, just like a public limited company. 7 members I incorporate this company. And when it is coming to acceptance of deposits, there's something called as net owned funds, which has to be considered. Net owned funds will be your paid up capital plus free reserves minus accumulated losses, and whatever is coming in that net owned funds, 20 times to my net owned funds, I can get loan. Beyond that, I can accept deposits. Beyond that, I cannot accept deposits. And there are 4 conditions a Nidhi company has to satisfy within 1 year from the date of incorporation, which is it has to have minimum 200 members. Its net owned funds should be minimum 10 lakhs. Its deposits to net owned funds ratio should not exceed 1:20, and at least 10% of my unencumbered term deposits should be in some investment assets. So these are all 4 conditions it has to be satisfied, and I can give loans. It goes very big in concept, Komal. Basically, this is what is Nidhi company is. So my sole work is here to accept deposits and to give loans. Any other specific doubt with related to Nidhi company, you can post your doubt. I will try to clarify that, because if I start explaining, the entire time will go for Nidhi company itself. Can a HUF be a member in a company? No, it cannot be a member in a company. When HUF is formed, what is the authority to be informed? No authority to be informed. The agreement is required. That's all. It's just like a partnership firm. What is the difference between society and a cooperative society? Societies are basically, the motto will be public welfare, whereas cooperative societies will be for the welfare of its members. So this can be the main difference between, and this can be for maintaining museums or zoos or whatever. So societies are basically, the motto will be public in nature. Where it comes to cooperative societies, only the members will be benefited. For example, if you take Amul, it is a cooperative society. Right? What happens when the directors of a Section 8 company doing fraudulent activity? Actions will be taken. This 10 lakhs, 1 crore, 3 years of imprisonment and all we saw, no? Labor laws, another faculty will be handling. I will not be handling. Exceptions to strike off, I've already told 2 times. Read me. I think you're only asking again. I've already told it 2 times. Nandini, how long recorded classes will be there in YouTube? You just type ICSI student in YouTube. You will find for all 3 hours the recorded classes will be there. And I don't think they'll be removing it. Again, it is on sole discretion of the institute. Sir, amendment up to what time should be taken into consideration for examination? 6 months before the examination, we'll have to check. Okay, after 6 months, any amendment is coming, you need not consider that. Before 6 months, whatever amendments are there, you have to be hands-on on everything. If possible, you only take the remaining syllabus. We all have Kaval. I'm little held up with my practice work also. We will see how it goes. You have my contact details. Any subject related doubt, you can ping me. I will try to answer your doubts. Okay, because if I have to handle everything, I have to check my time also. I'll not be able to handle. I'm sorry. I would love to do it. This situation, it is a little difficult right now because Corona. No staff come to my office, so I have to take care of all the work. So little hectic. I'm sorry. Can you explain difference between asset reconstruction company and factoring company? Both are into the same type of thing only. But then when I talk about asset reconstruction company, it more of falls under Sarfasi Act, where I securitize my assets. Okay. Change of company from one state to another state requirement. I've already said about shifting of registered office from one state to another state. Yeah, partner is not a partner by holding out is actually not a partner as per partnership act, partnership deed. Yes, as per the partnership deed, it can be the nominal nominal partner or partner by holding out. These two persons, they will not have their names in the partnership deed. Someone asked, what is the procedure for registration of patent in India? So a patent is basically an exclusive right granted by the government to the investor, for the inventor, for any new invention that they have done, or for any improvement in the existing technology for a specified time period. Okay, and if you are a startup company, you will have a rebate on your patent fee up to 80%. So what is the process to get your patent registered is an application to grant of patent has to be made in form 1 in duplicate. Then a provisional certificate on the specifications of that invention has to be given in form 2, along with the descriptions, claims, drawings, everything. Then a statement of the undertaking has to be given in form 3 in duplicate, saying that I undertake these are all being done, and if this will not create any damage to anyone and all these things. Then a power of attorney is, suppose if you are appointing an agent to a patent agent to appear on behalf of you, then a power of attorney in Form 26. A declaration of inventorship has to be given in Form 5, saying that I only invented, this is my true invention. And a Form 28, if you are a small entity, also, you will be given preference for your patents and there will be reduction in your fee. So Form 28 has to be submitted when the applicant is a small entity. And all other priority documents have to be submitted along with the requisite fee. If you are going to apply this, it's an online process. Your patent will get registered. This is how you normally register your patent. Then if a company is converted into LLP and the assets in this is sold and amount is there before cooling period of 3 years, will the sale proceedings can be shared between the partners? Will it be counted as capital gains to partners? Kalyani, I am really sorry, I am not very sure on this capital gains. Because taxation, I'm not very sure. I don't want to comment on things what I don't know. The word estoppel normally refers to unavoidable. Okay, in different places, wherever estoppel is there, just put this word, not unavoidable, you cannot say no, it is not correct. Okay, so that is what is estoppel basically mean. Minimum number of members to form a trust? No, you should have one settler, you should have one trustee, two trustee, no problem. The minimum number is there should be a settler, there should be a trustee, there should be a trust property, there should be a beneficiary. Padmavati. Minimum number of members to form a trust. NBFC related suits also will be filed in NCLT only, to my knowledge. Sir, for Nidhi company, pledge any asset lodged by its member as security. Yeah, when it comes to Nidhi company can give loans only on secured, can give only secured loans. So when members are going to give some secured loans, what kind of assets they can give a secured loan is 3 types of assets. One is jewelry, one is immovable property, another one is any savings certificate or your insurance schemes or whatever it is. So when it is your jewelry, the maximum period of loan will be for 1 year. When it is for immovable property, the maximum period will be for 7 years. And when it is your saving certificate, the tenure of the saving certificate will be the tenure of the loan. And whenever you're going to give your immovable property, only 50% of the value of the immovable property can be given as loan. Okay. So this is what about that answer. Requirements for changing the register one office to another office already answered. Repeated questions are coming. Yeah, now since the exams are postponed, you have to take amendments till 2020, July 2020. Logo registration is basically your trademark registration only. You have to, again, this is an online filing where you will have to check the class in which there are 45 classes for trademark. You have to check in what class this would fall. You have to do a trademark search. If there is no resemblance, then you can make an application in Form TMA along with the requisite fee. If you're an individual, the fee will be 4,500 rupees. If you're a company, the fee will be 9,000 rupees, along with a user affidavit and a power of attorney. And if there will be a waiting period of 6 months, where 3 months will be for public people to give their objections, there will be an examination screening, after which your logo or your trademark will be registered. Okay. Difference between public trust and a private trust. See, normally trust, based on who's the beneficiary for the trust, it will, we can decide which is a public trust or a private trust. If the beneficiary for a trust is a particular person or a particular group of people, it is a private trust. If the beneficiary of the trust is going to be public at large, it will be a public trust. Just by looking who's the beneficiary, we can understand whether it's a public trust or a private trust. Yeah, estoppel means undeniable, Kavita. Correct. So, okay, we'll end with this. We've discussed a lot for today. When you're writing for exam, uh, first thing, try to, now you have time. Don't be in a hurry. And I would prefer you, I would actually like if you don't clear, if you're not sure with the concepts, because just clearing the examination is going to be of no use to you. If you are going to understand the concept and then clear this exam, only then it will be useful for you. Without understanding the concepts, it can not only for this particular subject, it can be any subject. Only if you understand and then you clear, that is worth clearing. Just by fluke, if we clear, it's nothing to be happy to feel happy of. Okay, because this is one profession where whatever you're going to study, you will be doing it practically in your life. So whatever I've been explaining so far, I don't read the study material, and I'm not saying to you out of my experience how I am working. I'm sharing all these things to you, which means that whatever we are studying, we will work practically. Okay, so you will have to make sure the concepts, you have to be very clear and study 2-3 times, and write module by module. You don't be in a hurry to complete all modules in one shot. There's nothing that is going to happen. The day you become a company secretary, you should be a perfect company secretary. And when it comes to exams, developing, write fast. That is why you as and when you are studying, take notes, keep writing and take notes, because your handwriting will, you lose hold on the pen and the paper, how you write. Okay, and check a lot of tips on how to present a paper neat, even though your handwriting is not good, but handwriting plays an important role. And answer all the questions, because at least 1 mark they will give. Okay, even though you write something related to it, at least 1 mark you will get. That 1 mark makes a difference. So try to attend all the questions as much as possible. Don't spend too much time for one question. Now, for example, they're saying what are the factors determining to choose a, there are 16 factors. Don't write for 4-5 pages and waste your time. If it is going to be a 7-mark question, then write all 14 headings and explain some 7 points, or explain everything in 2 to 3 lines. Don't spend too much time on in any, because if you're going to spend 4-5 pages for one question, you should have consistency. All answers of the same type should be written for so many pages with so much of consistency. Okay, so numbering is very important. Number the questions very well. Don't jumble and write. So some people would say write whatever you know first and then write. I would normally differ from that point of view, because it would be very hard for an invigilator to keep changing, because he has to make a note of how much marks he's putting for each answer. Okay, so when you keep jumbling and writing, he gets irritated. So you go in the flow is what I would normally prefer. If you don't know too much about it, don't write too much stories on it, because the next thing what they see, they start thinking you're writing stories only. Okay, study from the scanners. Scanners are good only. What I would normally prefer is take the scanners, see all the past question papers, have a clear-cut understanding on all the questions that are being asked. When it comes to the answers, don't write whatever is there only in the scanner. You have to write even what you know more about that particular question. Okay. Sujata scanners. I think in you can find them. 1 second. I'll try to take the link and send it to you. See, I've given you the link in the chat box. You can just go to that website and you can purchase it online, because due to COVID, a lot of shops will be closed. Few people would be staying in a remote places where you will not have access to all these bookshops. You can book it online. They will courier it to you. Okay. So what I'm saying is, have an understanding on all the questions that are being asked, and don't get panicked. Whatever you know, you write related to the question and keep moving to the next question. Okay. So paper correction is tough. Paper correction is tough because you will have to come, when you're coming out, you should be a good product. Okay. It is our institute. Tomorrow you're going to be a member in this institute. When you're going to be a member in this institute, you should be in a position to be a good company secretary with good knowledge. No one should say, we don't know how he cleared itself. No one should say you like this. That for that reason, it is tough. Yeah, taxman scanners are also good only. Scanners are basically used to understand the pattern, how the past questions are being asked, so that we can get ourselves prepared in that way. Yeah, share your personal experience with us. See, I really enjoyed all these classes, all 6 classes that I've taken with you. There's been a lot of enthu from your side. All of you are very interested. This interest will surely make you to clear, is what I normally feel, because when if I was a student, I don't think I would be sitting for 3 hours and listening to all these things, whatever any faculty, even though faculty is good or bad. I don't think I'll be in a position to sit for 3 hours in front and I'll be watching everything. This shows the amount of interest that you people have in the subject. So actually, I was yesterday when I was mailing to the institute about the feedback, I was saying the class is too good. They're very interactive, and I'm enjoying the classes. And actually, I also feel a little bad because today is my last class. Tomorrow, I'll not be able to spend time with you people. So I feel a little bad also, because the classes are getting over for me. But yeah, thanks. This is a good memory during the COVID time, because this I've never taken classes like this earlier, because there used to be, I used to go to institute and we used to take face-to-face classes. This is something new for me as well. Kavita, today is my last class. Yeah. Even I will miss all of you a lot. So fine then. Take care. Write your exams well. If you are able to clear the exam in one shot, good only. If you're not able to clear also, don't feel bad. There's nothing to feel bad. This is not a BCom subject where you write whatever you want and you can clear. These are professional courses. 1-2 attempts will happen. You will come up in flying colors. You will become a great professional. For no doubt, you will be a great professional. So just write, give your best. If you're not able to clear, next attempt. In the next 6 months, you have the next attempt. But don't leave hope. You may not become a company secretary immediately, but definitely you will become a company secretary. So please don't leave the hope. Don't leave the course. Continue to study well. Okay. All the best, all of you. I am closing the session then. Okay. Take care. Thank you.